Dear friends, the Honorable Madras High Court, Dr. Justice Jayachandran delivered a landmark judgment on Section 340 CRPC. You all know that Section 340 CRPC is a procedural section, and it should be read with 191, 192, 193 of the Indian Penal Code, the substantive law. It is basically about the false statement that is being made and in the affidavit, and the judge, based on that false statement, suppression of evidence, fabrication of evidence, decides the case in your favor. It is a very serious offense which affects the administration of justice. And perjury, this is called as, in one word, is perjury. The landmark judgments were there, starting with the Pritish versus State of Maharashtra, and Crl.A.No.638 judgments. That's a constitutional bench of Honorable Supreme Court decided. And latest was the decision of the 3-judge bench headed by Justice Kaul in the matter Jasbir Singh versus State of Punjab. But this case, this judgment of Honorable Madras High Court delivered by Justice Dr. Jayachandran is landmark so far as the issue of interest of justice is concerned. Administration of justice, interest of justice will be the guiding factors for a judge taking a decision, because this is a discretionary jurisdiction. And you all know that, for example, a person is making a false allegation in the affidavit, or the person is supposed to say something but he knows it's false, but he says, and he doesn't say, suppress the evidence. In all these cases, the test is, if the court had been known those facts, what court would have done? That is the issue. And whether the court has relied on the facts, alleged facts, false statements made by the person, and decided the case. That is the main acid test. The procedure is drafted well, because this is a case where, one person is filing case against the other person. A neutral man will think they are offended. Unless you are offended, your rights are violated, you won't pursue it normally. And it is a cost. Litigation is a very costly exercise. And whether this person is genuinely doing this in the case of to protect himself, then that is a genuine case. But sometimes, interest of justice. So the lordships have decided what constitutes interest of justice. This could be the basis for any person who is defending the client alleged of false statements. So the law is well settled. And suppose you believe that they have made a false statement at any stage of the proceeding, the case would have been completed. It's gone to appellate court. And then appellate court also would have believed it might have gone to Supreme Court. But then later something is decided, and then you come back. Normally you are supposed to come to the lowest court where the offense has been alleged to have been committed. But we'll see. That part will be discussed later. But in this particular case, what does constitute interest of justice? Dr. Jayachandran, as you know, all of us know, sits in the criminal justice system. Justice Anand Venkatesh sits there. And earlier, Justice P.N. Prakash was sitting there. And Honorable Justice M.M. Sundaresh was sitting there. And all people of highest integrity. That is one thing. In that justice, they will be very brilliant people will sit, because the problem is that it's not just brilliance of knowledge, but then the application of knowledge. Suppose you apply on somebody and that man is put in jail, because the consequence is jail, penal provisions. It will have adverse consequence, right to life, right to liberty, precious of the fundamental rights. So therefore, the judge should have to take the holistically. And Dr. Jayachandran sir is so strict, and I recently appeared. The same recall petition is mine. It wasn't being listed. So that the court officer, that not the court officer, that sits in the court registry, that officer who posting clerk is called. He told me it is coming. For a long time it was not posted. So he said it's coming tomorrow at 2:15 hearing. Then we have prepared everything, well prepared. And then when we saw it is not come. So I thought I'll go and mention. So I went and mentioned before their lordships. And immediately the lordship said, "You are a liar. You're telling lies. I will never hear your case." I was shocked. But I knew he is a very good judge. That's everybody says he listens very well, very knowledgeable. So, but there should be some reason for him to come to that conclusion. Otherwise, nobody will just like that say. So I went and asked the clerk, posting officer. I used the word wrongly, officer. So the posting clerk said, "No, it is listed." Then where did you go? And I said, Justice Jayachandran. He said, "No, it's coming before Justice Anand Venkatesh." And I went and told that madam, and she was also upset. So sometimes it does happen, but there won't be any ill will or any intention of the judges. But a very good listener, and this judgment is very good judgment. I want everybody. It's beautifully written. Entire 340, 193 is analyzed. Judgments. But his conclusions are on para 29, 30. And how he concluded, how the court concludes is a part of our discussion. The case in short is like this. This is the case. I will show you what is the case and all. We'll take up that. Yes. Yes. This is the case. High Court of Judicature Madras and pronounced on this date. See, within 7 days he pronounced it. And this is the case. What happened is, the lordships, after seeing the facts, that is, I'll tell you the sequence also, you can understand. This is a matrimonial related case, husband and wife. So the husband and wife were married in 1996, and the marriage lasted up to 2009. So about 13 long years they were living or not living together, and they were quarreling. In the end, the marriage was annulled. During the subsistence of marriage, the madam filed Gokila filed a case against the husband, Murugesan. And she, in the affidavit, what she said is, "I am not working. I don't have any source of income, and I am depending on my parents and brother. And I'm to take care of my child. Therefore, you have to pay me maintenance." That's how you can ask for it. You cannot say, "I have so much money and all." So the judge during the course came to the conclusion, yes, she is in trouble. She needs to be taken care of. Ordered compensation, that is a maintenance, 2,000 rupees for her, 1,000 rupees for the child. And later he paid some 1,96,000. And thereafter that Kokila filed petition for divorce, and then the marriage is annulled. All right. This is 2009. In 2016, this husband, yes, erstwhile husband, filed a case. And Yes. The husband filed a case. He must have done some research on her, who is living happily. So, married and all. So, he found that she was working as a teacher. When she made a statement that she has no source of income, and he found that she was teaching. So, she had a source of income, but she lied. And second, he also found that she is married. She didn't mention. So these two factors he came to the court. Now, the procedural code is that you are supposed to go to the same court where the offense alleged to have been committed, the false statement has been made. There, the test for this court is called as referral court, because that court will have to come to an opinion either suo moto or by way of a complaint. And there are certain conditions laid down. In Pritish was the state of Maharashtra, and the subsequent, that's a constitutional bench of the Honorable Supreme Court. What has happened is that the first referral court will have to necessarily admit that case as the miscellaneous petition, rule 1. Secondly, it is between the complainant and the court. The respondents have no role because this is a preliminary inquiry. Generally, everybody will tell them to call, see that opportunity of being heard like that. There is an inquiry. It's not a trial. So the court, called referral court, which comes to an opinion or not, will have to decide whether there is a case made out, and that called findings. And that court has to record those findings. And then ask the magistrate court to take them in. That means normally if you are aggrieved, like a defamation, straight away you can go 200, you file the case, private complaint. But here, the object of intention of legislature is, one side is, people cannot take justice system for granted, because the judge will decide based on the material placed before him, the pleadings before him. He cannot be expected to go deep into that. Based on those evidence only, he has to decide. Suppose that evidence itself is wrong and he convicts somebody, because penal laws are very harsh, and then the consequences will be drastic. And I remember one of the very senior judge who retired. Then he was talking to me, you please speak to me about Ramayana, I'm restless, and like that. Because it's not so easy in a criminal justice system, judge sitting and passing the orders, because any small mistake will haunt them and their families and all that. That's what the Tirukkural also says. Yeah, any judge, why should he convict somebody and all? He'll have to take very difficult job it is. And the person aggrieved, he would have done murder also, but he will not accept that he has done murder. So he will abuse the judges. This is the problem. So that referral court, these are the procedural aspects. Finding is very important. Admission as a miscellaneous petition. Calling for the records if you are fabricated from the registry, and if there is affidavit, then calling for the affidavit that has been filed to understand the mistakes done. And then, so even there is a fact that the offense is made out. It's not just like that they should decide, refer to. They have to record reasons. And the record reasons in the interest of justice and in the interest of administration of justice. Unless that is established, it is not possible to establish the case. And see how this learned judge analyzed this subject. That is a very important fact. So what happened? That referral court decided. The referral court decided, yes, it is a clear-cut offense made out, and then asked for initiation of criminal procedure court to set motion. And magistrate, so that lady challenged it under before the Honorable Madras High Court. Criminal OP 638 of 2015, the case was filed. When the divorce was complete in 2009, 6 years thereafter. and the case was being heard. And because that 22, 6 years, now as on date is 22, and 13 long years gone. So the judge, so far as the factual information is concerned, there is no dispute. But the judge, when he analyzed the order passed by the referral court, first and foremost step, there is such a great large delay. 2009 divorce took place, and prior to that they were all fighting each other, and that lady is married, this fellow is also married, and normally in marriage relationships, no, the husband will be in dominant position. He will be thinking that wife is in trouble, and all. He'll get married fast, and but later when he comes to know that wife is happy, he cannot take it. And the same thing happens to the wife also. And cases will be filed. Some lawyer you go and meet, then he'll say yes. And never ending litigation. And each people will be, see, whole your life is in trouble. You are daily fighting a criminal case against each other, cross complaints. You have to buy a peace, family relationship. Here, it is not a case where the husband has cheated the wife and then married and she is in dire state. Nor a wife has cheated the husband and a husband is in a... Here they parted for good and they are living peacefully. What is this nonsense? That is the first point the judge took it. So he has asked the first question that the referral court has not given any reasons why there is a 13 years delay. A long delay because case is decided 2009 to 2016, 7 years. So why there is a delay? It has come to court and 7 years after that or 5 years after that will be wrong because this case would have been settled within few days because it is between you and the complainant only. Here, friends, let's go through the next step. And that is latches. The judge took that as the thing. So there is need, see, in a criminal law, the crime never dies. So therefore, Limitation Act doesn't apply. But at the same time, unless they specifically made, still crime never dies. But you have to justify reasons for the delay. It should not be a vendetta. You are attacking a person for no reason. And you are defending against somebody attacking you. And you are put to irreparable loss because of that illegal acts, then it is you have a great chance. But this is a case where absolutely the case, that is starting itself case is that maybe that judge, the lawyer at that lower level didn't appeal properly, argue the case. These are the ingredients of this case. Then the lordship said, why are you litigating all the time? You see cross litigations on this small fact, on this issue. Because one false statement can go to any extent. Using that, you can file criminal defamation, you can file disciplinary cases against if it's a professional. N number of cases. Today, the economy is growing and all people have money and lawyers are there to take it. So, that was the question. Second, he said, what is the, suppose if he's going to punish that lady, what is the ends of justice will be met with? She is happily living with the children and husband. And that person is also living happily. So is this going to come to an end? If this case is not there, they'll go to Supreme Court. So the cases will be ending. And so she said, the law is in the interest of justice means what? Put an end to litigation. Put an end to worries between the people. And once for all, they will, for 1 month, they will think this side, that side. Thereafter, they'll calm down. They know if it goes to Supreme Court, it will die. Immediately will be dismissed in SLP. And at least they will save some fees for not paid. And that you see, the case, yes, 2 paragraphs, but lordships are very intelligent, but still he appointed amicus curiae, took all the opinions from him, analyzed everything, and then he decided that she did wrong. Here is a case where the person made false statement attracting 191, 193, but based on 340 procedure, 341, 340 is decided referral court. 341 is the appeal court. So we will come there. Later I'll take detailedly for students. All the judgments I will read. I've studied this case detailedly. All these cases, criminal law, since I have to teach all the students. All 100 colleges, these judgments are going, analysis of important judgments, which I consider as important. You see how we analyzed. This court, on apprising the facts in entirety, finds that no doubt the perjury is caused by the appellant. But to prosecute her after a delay of 12 years will neither secure ends of justice. Ends of justice means if somebody has murdered, then that person should be punished. Here, what is the offense? It's just offense is made out, but by punishing her, will it serve the purpose? And nor expedient in the interest of justice. Ends of justice, interest of justice. Interest of justice here is, litigation will go on. The courts will be burdened with too much of cases. Recent judgment of Honorable Chief Justice, DYC Justice, sir, you find that when continuous litigation, you find that fellow and then put an end to the litigation in the Supreme Court. Counter, they'll not, once you get into court matters, you will never come out. This is one thing anybody should learn. Lawyers means they have to always be going inside, but arguing the matters. But clients, litigants, they cannot, this luxury of justice, this thing is very high. Now, second point says, so ends of justice. What is ends of justice in this case? By punishing that lady, will the society think, oh yes, offense is done. In Ramayana, if you see, Ravan is going to war. When he's going for war, Mandodari will ask him, when Ravan says today, either Mandodari will be a widower or Sita, then Mandodari will tell, my dear husband, why are you doing this fight? What is the purpose? Why? I will get fame. That is why everybody fights. Then she will ask, what fame you will get? Fame means somebody has to talk about you. That is called fame. Reputation is what others speak. Understand? It's not you are dead means who will be there? So today nobody is alive. Your son died, brothers, everybody is finished. So even assuming you will win against the dead bodies of your own people. If you die, whole world will think, good happened. You are a niche man, you are died. If you win, this is what is this God? Dusht, Anachari as one. So in no way it is beneficial to us. So you better do Sandhi. Compromise karo. So same thing here also. That is what the lordships have applied. Because where is the ends of justice? In either ways, if the judge convicts her, he will be looked as a person, a very strict interpretation of law. You understand? The sensitiveness is understood by this judge. This is a very good point. And expedience in the interest of justice. Now, this is a case, if his case is not completed at this stage, they will be fighting for life. Understand? Burdening the courts. That is the two important distinctions you have to understand, in my opinion, my dear students. Considering the multiple litigations between the appellant and the first respondent. See, this court is of the view that in the interest of justice, you understand, interest correctly has done it, in order to avoid perpetual precipitation of ill will among them. If you keep on fighting in the sense, somebody has, you have to defend yourself. This is interest of justice which the courts should consider. When the complainant is aggrieved, unreasonably attacked, even assuming you are going to close this against him, he'll be put to great injury. That is also to be considered. Here, nothing will happen. If he is closing the case, she will go her own way. That fellow will go her own way. But there may be situations, the complainant is aggrieved. He would have lost everything. And suppose the court is against him, he will be put to further trouble. Then that is not called ends of justice. So therefore, the dictum laid down by this thing, beautiful judgment, which we'll take every judgment, dear friends. It is a beautiful judgment, except for Jaspir Singh for the state of Punjab. Everything is covered. If you read this judgment as on date, everything is there. And one Mr. Manoharan has done the job. The judge is appreciated for his things. But more than the Manoharan sir has done beautiful, but the way in which judge, see, ratio decided is 31. A judgment is something which lays down the law that is applicable by the below courts. Therefore, he has taken condonation of delay. Why you have condoned? And if you had analyzed, you would have got a acid test. To continued litigation between the parties to put an end to their own peace as well as the peace of the courts also. And the matter ends there. It's a beautiful judgment, dear friends. Thank you very much.